My Lords, my Lady, I appear on behalf of the Secretary of State for the Home Department, along with my learned friend, Ms. Parsons. The D8, the respondent, is represented by my learned friend, Mr. Southey, King's Counsel, and Mr. Barrett.
Very good.
My Lords, my Lady, this is the Secretary of State's appeal against the decision in the judgment of the Commission dated the 19th of October of 2003 to set out the stall in relation to the bundles. First of all, the court should, I hope, have 3 bundles. Firstly, a core bundle with tabs 1 through to 15, a short supplementary bundle, and a relatively short authorities bundle as well. So those are the 3 bundles we'll work from.
Yes, thank you.
There was one issue I know that was identified by the court at the end of last week in relation to tab 11, that is the immigration rules. We have some fresh copies of those of 2 versions. If I pass those up to you now, they're marked, I'm afraid they're not paginated, but they're marked 11A and 11B. And if I just give you the copies for now, I'll return to those later on in my submissions.
Is this in the same form as came in electronically?
No. This is a completely new tab 11 and 11A and 11B, designed to, I hope, make the navigation of the immigration rules a little bit easier. The first version behind tab 11A are the rules that were in force between the 5th of October 2020 and the 30th of November 2020. That is the date when the original revocation decision was made. And behind 11B, we have the rules that were in force, as they were in force between the 28th of June 2022 and the 9th of August 2022, the date when the asylum decision was refused. So that the 2 sets of rules that were applicable at those 2 times.
Right. Thank you.
And what is it we have at the existing current?
The original tab 11 before the replacement version at 11 before the replacement version was sent, related to those, I think it's not entirely clear, related to those that are currently in force, and in fact they weren't even reproduced properly. The second version that was sent at the end of last week, I'm afraid I'm not sure exactly what date those were in force in, because I simply requested that they be replaced with the 2 versions that your Lordship now has.
Right. So we should take out, should we?
I think
forget
yes,
the original
if you take out the current tab 11 and simply replace it with the new version that I've passed up, I'm very grateful.
Thank you.
In terms of order of submissions, my learned friend Mr. Southey and I have discussed this. I would intend to set out the Secretary of State submissions in respect of their ground of appeal. Mr. Southey will then respond and respond to that and set out submissions in relation to his across appeal. I will reply to that and any additional matters I have that remain to be dealt with in relation to our appeal, and then finally Mr. Southey will have the final word in relation to his grounds if that meets the approval of the court.
Yes, and that seems fine. I think we've got 2 days allowed for this, but it's unlikely to take the full 2 days, isn't it?
I don't think it's going to take 2 days. It may be. I can obviously only control what I've got to say, but I'm going to be, I hope, relatively short on my points. It's always hard.
Well, unless we are very pressed for time, which I don't think we're going to be, it would certainly be convenient to me if we rise at 3:45 rather than 4:15 today. So let's hope that we're on course to be able to do that.
My Lord, yes, I'm grateful for that. Well, my Lord, the the Secretary of State's ground of appeal is set out behind tab 2 of the core bundle, page 15.
Yes.
Single ground of appeal that the Commission was wrong to find that as a matter of law, the Secretary of State must balance the degree of danger to national security against the cost, practicality and feasibility of any measures taken to ameliorate the risk. I will refer to that in shorthand as the balancing exercise, if I may. And it continues, and must demonstrate that she has regarded the Article 33(2) exclusion as a matter of last resort. That ground of appeal arises out of the Commission's decision that the terms of Article 21 of the Qualification Directive, along with Article 33, subparagraph 2 of the Refugee Convention, as interpreted in the case of T and Land Baden-Württemberger, 2016 First Weekly Law Reports 109, which again I'll refer to simply as T for shorthand, that those articles and that case required the Secretary of State to balance the degree of danger to national security against, as we set out in the ground, the cost, feasibility, practicability of any measures that could be put in place to ameliorate the risk. And that effectively reflects, if I can refer you to the judgment of the Commission, please, behind tab 7 in the core bundle. Page 110, paragraph 194. That's the key finding for the purpose of this appeal, where it sets out the finding, and effectively that the decision of the Secretary of State had to be a measure of last resort. And in D8's case, the Secretary of State had not conducted such an assessment, and as a result, the appeals in respect of revocation and the refusal of asylum application, though it became academic as a result of that appeal being allowed, that they both succeeded. And again, this is just laying the ground, if I may. If you move forward in the judgment to paragraph 282, which is at page 125, the Commission stated that if we had concluded that Mr. Kinnear's submissions on the law were correct, we would also have concluded to adopt a shorthand that the national security case was made out. The consequence would have been that D8's revocation appeal would have to be dismissed for that reason alone, or reasons are set out in clause. We don't need to look at the clause. This is a matter of pure law. So in our submission, the error that we submit that the Commission made resulted in a finding that D8 effectively was not a danger to national security in the terms as the Commission said were set out in Article 21 of the Qualification Directive. We submit, if, as the Commission itself said, if it had followed the submissions that we had made, i.e. that there was no balancing exercise, it was simply a matter for the Secretary of State to determine on all of the material before them that there was a danger to national security, that both of those appeals would have been dismissed. And in that regard, in our submission, it's important to note that even if this appeal, the appeal that your Lordships and my Lady are hearing, even if this appeal were to be successful, D8 would not be refiled or returned to Iran because he was successful in respect of his ECHR Article 3 appeal, which the Secretary of State doesn't challenge, and as a result of that he would be granted some form of leave as per paragraph 293 of the judgment, where the Commission state, in the event that virtually all our foregoing conclusions were reversed on appeal, that the safety on return finding were to survive, again, which it's not challenged, its Article 3 appeal would succeed. Ex hypothesi he would not be entitled to asylum or humanitarian protection, but he could not be safely removed to Iran. It would be for the Secretary of State to determine how our finding should be reflected in the grant of some sort of leave to enter remain in the United Kingdom. And as we go on, that in our submission is an important point.
Yes, I mean, the irony is of the case, in a way, is that because of that, which the Secretary of State now accepts, in practice, something rather like what you have called a balancing exercise will have to be done anyway, because he's going to be here, and Secretary of State will have to consider or somebody will, what measures need to be taken to ameliorate as best as possible the risk that he presents.
Indeed. But we submit that perhaps the importance of that as well, although it didn't happen in this case, the Secretary of State could themselves have reached that conclusion. But in our submission, that's an important point, because it highlights that the two decisions that are under appeal that we submit, when I get to it, that those were not and are not decisions to refile.
I'm so sorry, Mr. Keir, it's my fault. I didn't get down the reference to the paragraph that you telling us about a moment ago before my Lord asked his question.
Yes, that was paragraph 293.
Thank you very much.
Beginning in the event that virtually all our foregoing conclusions. It's on page 120.
Thank you very much. It's just I was writing a note about something else and lost the plot, as it were. Thank you.
So in terms of our single ground of appeal, we advance two alternative arguments. Firstly, that the qualification directive is not retained EU law, such that neither it nor the interpretation of it in the case of T were relevant to the appeal in front of the Commission. And secondly, and in the alternative, that the revocation decision and the refusal of the application for refugee status were not decisions to refile D8, and that T was effectively of no relevance to his case. Before I come to develop those two grounds, can I just set out some of the key dates and take you to, in particular, the decision letters that notified D8 of those decisions?
Yes.
Firstly, on the 17th of February 2016, D8 entered the United Kingdom and claimed asylum. That's the 17th of February 2016. That application was refused, but his appeal was allowed by the FTT on the 30th of March of 2017, effectively as a result of surplus activities on his part. And following that decision, on the 23rd of April 2017, he was granted leave to remain for a period of 5 years. On the 19th of February of 2020, D8 travelled to Iraq via Istanbul, and then sometime on or around the 5th of March of 2020, he returned to Iran. And you will find in the judgment that we've been looking at reference to that particular finding of fact at paragraph 241, where the Commission found, taking into account the whole of the available evidence, including the intelligence picture enclosed, we find as a fact that D8 was in Iran between 5th of March 2020 at the very latest and late April, early May 2020. Of course, the issue that the Commission then went on to consider was whether the Secretary of State had been able to prove that he had effectively re-availed himself of protection of Iran, but the Commission found that the Secretary of State was unable to prove that he had returned openly to Iran. And again, there's no challenge, obviously, to that particular factual finding.
Yes.
During that particular span of dates, on the 2nd of April of 2020, D8 was excluded from the United Kingdom on grounds that his presence was not conducive to the public good for reasons of national security. And then on the 15th of October 2020, tab 4 in the core bundle, please. I apologise, that's incorrect reference. It's tab 12, please, page 163. This is the letter dated the 15th of October 2020 informing D8 that his refugee status had been revoked. It's tab 12, page 163. And it sets out within there the reasons for the revocation. Paragraph 6, paragraph 338A of the immigration rule states that a person's grant of refugee status under paragraph 334 shall be revoked or not renewed if any of the paragraphs 339A to 339AB apply. A person's grant of refugee status under paragraph 334 may be revoked or not renewed if paragraph 339AC applies, and it's paragraph 339AC that this appeal is principally concerned with. At paragraph 7, you can see that it refers back to a previous letter of the 24th of April of 2020, which had set out that the Secretary of State considered D8 to hold an Islamist extremist mindset, and that he was supportive of the Islamic State of Iraq and the Levant, ISIL, also known as Daesh, prescribed terrorist organisation. So that was the core reason. Paragraph 8 sets out the Secretary of State has fully considered the case in line with Article 1FC of the Refugee Convention. That was given as one of the reasons for revocation. It's clear from the judgment that the Secretary of State, via me, had abandoned that particular ground during the course of the hearing in July of 2023, so it's no longer relevant. Then at paragraph 9, over the page again, perhaps the most relevant paragraph for these purposes. Furthermore, the Secretary of State is satisfied that your Islamist extremist mindset and support for ISIL means that there are reasonable grounds for regarding you as a danger to the security of the United Kingdom. As such, paragraph 339AC, Roman numeral 1, applies to you, and your refugee status is therefore also revoked on this basis. And of course, at that particular time, when that letter was sent, D8 was not in the United Kingdom. And our submission is that that positively was not a decision to refile him or to return him to Iran or indeed anywhere else. Because the next date is the 23rd of March of 2021. And that is the day when D8 returned to the United Kingdom on a small boat and made a claim for asylum and humanitarian protection. core bundle then, please, tab 11, going back one tab. The next relevant date is the 8th of July of 2022. It's the date of this letter. And this is the letter which refuses his claim for asylum and humanitarian protection. We can see, dear D8, your claim for asylum and humanitarian protection, your protection claim made on 23rd of March 2021, that's the date of his arrival, is refused. Secretary of State has also decided Article 33(2) of the Refugee Convention applies to you. And that's a short letter, but there then follows from page 137 through to 162 quite lengthy reasons for the decision that had been made. At paragraph 3, I'm not going to go through all of this, but at paragraph 3 it sets out, furthermore, there are reasonable grounds for regarding you as a danger to the security of the UK in accordance with Article 33(2) of the Refugee Convention. Therefore, the Secretary of State has decided you do not meet the requirement of Immigration Rule 334, Roman numeral 3, the immigration rules, and accordingly, pursuant to paragraph 336, refuses to grant you access. So, effectively, the reason for the revocation and the reason for this refusal were the same. That is, the danger to the security of the United Kingdom, danger to national security. And at paragraph 6, it deals with your eligibility for humanitarian protection has been considered against the criteria in paragraph 339C of the immigration rules. However, since there are serious reasons for considering you are a danger to the security of the United Kingdom, paragraph 339D of the immigration rule applies to you. The Secretary of State has therefore decided that you are excluded from humanitarian protection. Next dates, if I may, please. There were then 3 national security assessments, all of which were before the Commission. They're not included in the bundle, but I'll give you the dates and also give you some references, if I may, in the judgment to where they're summarised. So the first national security assessment was the 7th of March of 2022. It's set out in, or summarised in judgment, which is tab 7 of the core bundle, paragraphs 65, 66 to 67, which is at page 83. If I just can refer you to that briefly. You will see the Commission has set out at 66 in MI5's first national security assessment dated 7th of March 2022. It was assessed that there are reasonable grounds for regarding D8 as a threat to the national security of the United Kingdom, and that his exclusion would be conducive to the public good in short. And they set out a quote there, the Commission sets out a quote from the National Security Assessment, which effectively largely reflects that which I'd read out from the letters previously. Final part of that paragraph, we assess that D8 maintains an Islamist extremist mindset and is supportive of ISIL and is a threat to national security. And then a little bit more detail at paragraph 67 was the part in relation to whether he re-availed himself of the protection of his country of nationality. But that
well, to the extent that the assessment relied on that finding of fact, it was flawed.
it was, in that respect, yes. And of course, as I've already pointed out, the Commission made a finding of fact in relation to that
Yes.
reveal. The second National Security Assessment, dated the 4th of November 2022, again is summarised at paragraph 68 of the judgment. And it dealt with some evidence in relation to bank statements and medical evidence, but effectively the assessment was maintained. And then finally, the third national security assessment was dated the 29th of March of 2023, and again it's dealt with in the judgment at paragraphs 69 to 70. Those last two assessments were dealing with evidence that D8 had, largely dealing with evidence that D8 had produced as part of his appeal. And then, of course, the hearing took place between the 10th and the 13th of July of 2023, with the judgment handed down on the 19th of October 2023. That leads me, if I may, to the first limb of the ground.
Is there a reason why the appeal's taken such a long time to come on?
It was originally listed to be heard. There is an order in the bundle, I can take you to it, my lord. It's at tab 13. There's actually an order that my lady made back in May of 2024. The appeal was originally listed for the 20th of June 2024 with a time estimate of 1 day. But what had happened, and not making any criticism at all, D8 was originally represented at the original hearing by Miss Knight's King's Counsel. I think the position is that she went on sabbatical, and there was a considerable length of time between the hearing ending, the Secretary of State lodging her ground of appeal, and then Mr. Sudley.
Well, we probably don't need to. I was concerned whether there was a reason, but
no,
it seems that
that's the reason. It was listed, and then it was just a matter of trying to find more court time for it to be dealt with.
Thank you.
So if I can move on then to the first limb of the ground of appeal, that is that the qualification directive is not, in our submission, retained EU law. We submit that the application of Article 21 of the qualification directive was central to the Commission's conclusion that the Secretary of State had to undertake the Article 21 balancing exercise beyond simply reaching a conclusion that D8 was a danger to national security. And we submit that if the qualification directive was not retained EU law for material time, or it wasn't applicable, then the reasoning and basis for dismissing, the basis for allowing the appeals was flawed, and it would in fact have meant that, as I've already taken you to, paragraph 282 would have applied, and the appeal should have been refused. Can I take you please to the judgment in the core bundle behind tab 7, paragraph 170 to begin with, please, which is at page 104. The Commission found at paragraph 170 states that Article 13 of the Qualification Directive confers the right on the individual to be granted refugee status, and Article 21.1 obliges member states to respect the principle of non-refoulement. These obligations remain on the United Kingdom following the United Kingdom's departure from the EU. In other words, they are retained EU law for the purposes of the European Union Withdrawal Act 2018 Act, and then there's a footnote 13 at the bottom. It says the route to this conclusion is not via sections 4 and section 6.7 of the 2018 Act, but section 2. The Commission is aware that this point is on appeal to the Supreme Court, and we understand that to be a reference to the Crown and the 3A's bracket Syria case.
do we not need to start at 168, which sets out that the background, which is the qualification directive, was not directly applicable to the United Kingdom. There was a requirement to transpose it by 10th of October 06, and this was achieved via the immigration rules and the qualification regulation.
My Lord, yes.
That's key, isn't it?
Yes. My Lord, there is no dispute that the immigration rules are retained EU domestic legislation as defined or as retained in Section 2.
Well, if they're domestic legislation, it doesn't matter whether they're retained or not.
Are they legislation?
Sorry?
Are they legislation?
Well, we think for these purposes they are, because they're made pursuant to the Immigration Act of 1971.
You might want to look at, as a decision of the House of Lords called Oldalola, which deals with the status of the immigration rules. I think a general view taken in the judgments in that case was that they're statements of policy rather than legislation, as I recall. It may not be straightforwardly the case that the immigration rules are legislation.
My lady, yes, can I develop this point and look at the decision of the
Sure.
Supreme Court in the 3A in Syria case as well?
Yeah.
As I said, we accept, the Secretary of State accepts that the immigration rules, subject to what my lady has just said, are retained law. But in our submission at paragraph 170, what the Commission was deciding there, what they were stating there, was that the directive, the qualification directive itself, was retained at EU law. And in our submission, that was an error, because it was a material error, and one which led to the conclusion that the more onerous Article 21 balancing exercise had to be undertaken.
But if you're right, if you're right in accepting that the immigration rules are legislation, and they're brought into force in order to implement, perhaps using that wrongly, the qualification directive, don't they have to be interpreted consistently with the qualification directive?
My lady, in our submission, when one then comes to look at the Immigration and Social Security Coordination EU Withdrawal Act of 2020, that is not the position.
So if we just take it in stages, before the 2020 Act, is it right that they would have been, they would have had to be interpreted
Yes.
consistently with the directive, as my lady has suggested?
Yes.
But you say, do you, that the 2020 Act reverses that
Yes.
point?
If there's a tension, if a tension exists between the two and the application of a new test.
So it's not a question of what legislation is retained, it's a question of how you interpret it.
Yes, I accept that. I mean, that's one of the submissions that we learned from Mr. Southey at King's Counsel meetings.
And is that dealt with in the legislation?
Well, in our submission, if you turn to, and I'll take you to it now, if you turn to the relevant provisions in the Immigration and Social Security Coordination EU Withdrawal Act, which is at tab 6 of the Authorities Bundle. And this is Schedule 1, which is given force by Section 1 of the Act. And this is in force from the 31st of December of 2020. Paragraph 6, any other EU-derived rights, powers, liabilities, obligations, restrictions, remedies and procedures cease to be recognised and available in domestic law so far as A, they are inconsistent with or otherwise capable of affecting the interpretation, application or operation of any provision made by or under the Immigration Acts. Working through that, in our submission, firstly, the immigration rules are clearly any provision made by or under the Immigration Acts. And in our submission, certainly the interpretation put on Article 21 of the qualification direction by T is capable of affecting the interpretation, application or operation of those immigration rules, and in particular in this case, Immigration Rule 339 AC, little Roman numeral 1.
So you say, do you, that the interpretation of the rules required by applying T is an EU-derived right, power,
Yes.
etc.?
Because the EU-derived power is Article 21.
Sorry, say it again.
The power that effectively is being used here, or used that the Commission was referring to in this case, was Article 21 and its interpretation in T. And in our submission, if and we submit that under our alternative limb to this ground of appeal, we submit that in fact the correct article that the Commission should have been looking at was Article 14 of the Qualification Directive, not Article 21. But assuming for the purposes of this argument that Article 21 was the right provision for the Commission to be looking at, when it was considering and deciding that T required Article 21 or consideration of refilement to involve the balancing exercise, that in our submission that is inconsistent with UK law, and certainly the way that the Secretary of State was interpreting their duty under and their approach under Immigration Rule 339 AC Roman numeral 1.
There's a difference there, isn't there, between saying we no longer recognise EU-derived rights as available in domestic law so that they cannot affect interpretation. But that's different. Is that not different from saying when we interpret the Immigration Acts, we can take into account that they were introduced by way of implementation of an EU directive which was then binding at that time? It's a different question, isn't it?
Well, that may be, my Lord, we would submit that the interpretation put on the Article 21 directive by the court the European Court in T is one that, if it is to be imposed, is incompatible with the UK state of the law, which is that balancing exercise doesn't have to be undertaken, and it's merely a matter of the Secretary of State making a decision, difficult decision in relation to the issue of danger to national security.
But you would accept, would you, that it did apply prior to IP implementation?
Yes.
So so English domestic law changed on IP completion day?
Well, it didn't change. In our submission, the effect of paragraph 6 to Schedule 1 is that if those provisions of EU law which are incorporated into UK law are effectively inconsistent with the approach that we submit the Secretary of State has to take, which is simply to balance consider the danger to national security and not complete a balancing exercise, then in our submission that is something which is capable of affecting the interpretation, application or operation of any
That
provision.
seems circular to me. Because if the domestic legislation, as it was, governed the approach to the Secretary of State, then it governed the approach to the Secretary of State.
Well, Lord, can I move on and return, I think, and look at that particular contention in light of some of the case law as well?
Just before you do, you've emphasised paragraph A. Is paragraph B relevant, or do we forget about that?
No, it's relevant as well, my lord.
I mean, they're alternatives, aren't they?
Yes.
So you put your case under both?
Under both limbs, yes.
And I see from subparagraph 2 that what is being talked about are rights which are recognised and available by virtue of, continued recognised and available by virtue of section 4. Is that why SIAC was concerned to say this is not a section 4 case but a section 2 case? Or is that something altogether?
Well, it may have been. There's one of the issues we would submit with the judgment is that there isn't a huge amount of explanation as to how that result has been reached. As I said, I've taken to the footnote in the judgment, which is really the only part of the judgment that bites in relation to the route that the Commission took in finding or concluding that section 2 was the route.
But I mean, if SIAC is right to say it's not a section 4 case, then doesn't this paragraph fall away out of consideration? Because it's saying, reading it rightly, which I may not be, that the reference in subparagraph 1 is to section 4 cases.
Yes. But in our submission, section 4 would be the only route to these provisions that the Commission was relying upon to be taken into consideration.
The Commission relied on section 2.
Yes, and which we submit was wrong.
Well, let's have a look at section 2.
Section 2 is in the bundle.
Why do you say section 2?
Tab 3.
Yeah,
No,
page
I
12.
apologise. It's tab 5, page 12 of the
Page 12, yeah.
bundle.
But why do you say section 2 is wrong? Because you've just accepted, you've said that the immigration rules are legislation.
Yes, we accept that the immigration rules are legislation, but in our submission, what SIAC found, what the Commission found, was that it was the qualification directive itself that was the retained EU law. If you look again, please, back at paragraph 170.
Right.
That's why I think you have to read 168, because what they're saying is that it has been implemented. So it has become EU-derived legislation.
We would submit that the qualification directive itself could not become EU-derived legislation under any of these provisions.
Correct. But it never can be, because as you said in 168, the qualification directive is not directly applicable.
It's the transposition of what was in it into the immigration rules.
Yes.
But if the immigration rules are legislation, then why doesn't their transposition of the qualification directive fall within section 2?
No, we accept that the immigration rules do fall within section 2.
Yes. So then, what's the answer to my question, please?
I apologise. Could you repeat the question?
Well, you accept that immigration rules are legislation, but if that's right, why aren't the immigration rules EU-derived legislation? Because as they had effect in domestic law immediately before IP completion date, they reflected the qualification directive as interpreted by the Court of Justice.
No, we accept that. We accept that, my lady. We accept that
Right.
they do.
Sorry, just let me note that down. So we accept
the immigration rules are caught by Section 2 of the EU Withdrawal Act 2018.
right. So the immigration rules, qua EU-derived domestic legislation, if indeed they are legislation, continue to have effect in domestic law. All right. So
And as it has effect means as interpreted by the Court of Justice. Because that's how it did have effect in domestic law before IP completion day.
Well, it did, yes, I accept that.
Right?
But our submission relies upon the provisions within paragraph 6 of Schedule 1 of the Immigration and Social Security Coordination Act, the 2020 Act, at behind tab 6, page 24. Because we submit that those EU-derived rights which are contained within Article 21 are inconsistent with or are capable of affecting in particular the interpretation, application or operation of any provision made under the
Forgive me,
Immigration Act.
but this is exactly, but Section 6 doesn't apply, does it? Because if what has happened is the qualification directive has been implemented in domestic law, then by definition it will not be inconsistent with it, and it can't affect the interpretation because it's already been implemented.
My lord, I see where you are going with that argument, but in our submission, taking this enhanced balancing exercise test from T through Article 21, the interpretation of Article 21, we would submit that is wrong and that is inconsistent with...
Well, that's the next stage of the argument, isn't it? I mean, how it applies in this case. I mean, at the moment we're just looking at what does this mean, and does this mean that if you've implemented a directive into domestic law prior to IP completion day, does that law then somehow change on IP completion day because the directive which you implemented is no longer available to interpret it? That, if you don't mind me saying, would be a very, very strange result, because it would change domestic law which has been already implemented many years ago, and it would leave it in a vacuum. Because what you're saying is you can no longer take into account that this was enacted by way of implementation of an EU directive, because that would be to interpret it in the light of the directive. And not only does that seem bizarre, it doesn't seem to follow from the wording of the legislation, which preserves in Section 2 EU-derived domestic legislation.
My lord, you have my submissions on that particular point.
But can we just understand a bit better the difference between Section 2 and Section 4 of the 2018 Act? Section 2 is concerned with EU-derived domestic legislation, which is typically going to be where a non-directly applicable EU measure, such as a directive, is implemented by something which qualifies as legislation under UK law, whereas Section 4 is concerned with rights, powers, etc., which are recognised and available in domestic law by virtue of Section 2.1 of the original 1972 Act, which sounds as if it is more concerned with direct applicability, for example, regulations. So there are those two routes by which EU originating law may become part of UK law.
Yes.
And then the Section 20 Act seems only to be concerned with the Section 4 route, that is to say, directly applicable EU legislation, not Section 2. Although the SIAC don't spell this out, that seems to me to be quite possibly the basis of the distinction that they're drawing, and on that basis, the immigration rules giving effect to the qualification directive are not recognised and available in domestic law by virtue of Section 4, but Section 2, and therefore paragraph 6 of Schedule 5, whatever schedule it is,
It's paragraph 6 of Schedule 1.
Schedule 1, is simply not applicable. Isn't that right? What's wrong with that analysis?
Well, my Lord, we submit that when you consider Section 2 and Section 4 and that schedule together, that the schedule effectively does include and allow or requires, we submit, Parliament is requiring the courts to ignore and not take account of any of that legislation which is inconsistent with the way in which the UK is approaching the law.
But can I ask you a further question, Mr. Kinnear? What happens if the UK, if Parliament wants to change legislation that would otherwise be affected by, that falls within Section 2? Is Parliament prevented from changing such legislation, or can Parliament amend that legislation?
Well, I don't think Parliament could be prevented from doing either, from changing, from amending the legislation.
So, if you're right, and the immigration rules are legislation for this purpose, your submission is that Parliament could amend them after IP completion date. Is that right?
Yes. I mean, that must be right.
It would be helpful in relation to the 2020 Act if we had the section that gives effect to Schedule 1.
Yes, I can take you to that in
Well,
another
I mean,
bundle.
I've printed it for myself.
It's
It's headed Repeal of Main Retained EU Law Relating to Free Movement, etc. And it says Schedule 1 makes provision to end rights of free movement, blah, blah, blah. B, end other EU-derived rights and repeal other retained law relating to immigration. I don't know whether that helps us understand. And we haven't got the rest of Schedule 6, Schedule 1, so we don't know what provisions precede the formulation in 6.1 any other EU derived rights. are all the provisions before paragraph 6 of Schedule 1 provisions about free movement?
Or provisions about what, my lady? Apologies.
Free movement.
I can just check that. Give me a moment. So, Schedule 1, Part 1 relates to EU, it's headed EU-derived domestic legislation. And Part 2 relates to retain direct EU legislation, which looks primarily to workers' regulation. And then Part 3 are the EU-derived rights.
So, sorry, is paragraph 6 in part 3?
Yes, paragraph 6 is in Part 3.
And is that the only provision in part 3?
So, paragraph 5 is any rights, powers, liabilities, obligations, restrictions, remedies and procedures which continue to be recognised and available in domestic law by virtue of Section 4 of the European Union Withdrawal Act.
I think it might be helpful, please, if we could be provided with Section 1 and the rest of Schedule 1.
We'll at lunch we'll get the whole of we'll bring the whole of that schedule as it stood as at 13th of came into force on the 13th of December 2020 and was amended on 1st of January of this year. It's not particularly long, it only has, in fact, paragraph 6 is the last paragraph in the schedule. Can I move on from that first limb, please, to the second limb?
Yes, please.
And
I'm sorry, before we move on, could I just ask you a further question, please? Do we get any help from the decision of the Supreme Court in AAA Syria about how all this is supposed to work?
well, there may be some assistance in it. It is behind. It's in authorities bundle behind tab 20. Starting at page 268. And as an overarching submission, we would submit that the overall effect of it is that any provision of EU law that is inconsistent with the immigration rules that was to be disapplied.
So the issue concerned a provision in the immigration rules, did it?
It was. And if I can take you through this judgment, I hope quite briefly. It's the judgment of Lords Reid and Lord Lloyd-Jones, with whom the other justices agreed. Their judgment starts at page 274 in the authorities bundle, and that they considered, I mean, there's a number of issues that were obviously considered in this case. Page 279, starting at paragraph 19, they considered the history of refilement in some detail.
I mean, are we helped by the reasoning from paragraph 107 onwards? That's
where I'm going. That's where I'm going to, my lady. The retained EU law point is dealt, as my lady has said, from paragraph 107 onwards under the heading Retained EU Law Introduction. paragraph 109, it states it's common ground between ASM and the Secretary of State that the effect of Section 4 of the 2018 Act was to preserve the relevant provisions of the Procedures Directive as retained EU law. And in our submission, effectively you could read in there the Qualification Directive. Paragraphs 111 and 112 set out effectively the nexus between the Procedures Directive and the Qualification Directive. You can see it at paragraph 111. It deals with the Procedures Directive, and then at paragraph 112 it states the Procedures Directive and the Qualification Directive were implemented in the United Kingdom in a piecemeal fashion. Existing legislation and rules were already compliant in many respects. Some necessary changes to the immigration rules were made for both directives, and it makes reference to the statement of changes and further changes being required by way of the qualification regulations. 113 to 114 then deal with the 2018 Act. Paragraph 113 simply sets out section 4 of the Act, and then at 114 it states it is common ground in this appeal that the relevant provisions of the Procedures Directive were retained EU law within section 4 of the 2018 Act. Section 4, as amended by the European Withdrawal Agreement Act 2020, provided for the implementation period, came into force at 11 p.m. on the 31st of December. So again, we would submit that for Procedures Directive there you can read Qualification Directive. And then paragraphs 115 to 121, the judgment goes on to deal with the 2020 Act, and perhaps the key paragraph is paragraph 120, which states the effect of paragraph 61A is to disapply EU-derived rights so far as they are inconsistent with or otherwise capable of affecting the interpretation, application or operation of any provision made by or under the Immigration Act. And that in our submission includes the immigration rules. They are dealt with over the page under that heading, paragraph 122. Paragraph 3, the judgment then sets out the submissions made on both sides in some detail, and page 309, paragraph 129, they deal with the interpretation of the 2020 Act, and again set out the submissions in detail. Paragraph 143 state that secondly the purpose of the 2020 Act is to end the application within domestic law in the United Kingdom of parts of retained EU law. As Lord Pannick observed in his written case, such an Act of Parliament should be construed fairly in accordance with its terms and not by reference to presumption that it applies to as little retained EU law as possible. And then the court considers the decision, its own decision in G, where these issues had been raised, but all of the arguments, not all of the relevant arguments have been put forward. And then paragraph 148 has a conclusion in relation to G. In circumstances where the point was not argued in G, the practice statement, judicial press in 1966 concerning the departure of the Supreme Court from services was no application. On the present appeal, the Supreme Court, having heard full argument on the point, has come to the clear conclusion that the effect of the 2020 Act is that Articles 25 and 27 of the Procedures Directive do not have effect in the domestic law of the United Kingdom as retained EU law. So in our submission, again, the same reasoning would apply to Article 21. It's not retained EU law following the reasoning of the Supreme Court.
Is there any clue in the law report about why it was common ground that Section 4 was the relevant provision of the Withdrawal Act rather than Section 2?
I don't think that there is.
That's paragraph 114. I can hear Mr. Southey's whispering something.
Yes, I think Mr. Southey's drawing my attention to, well, it's paragraph 107. I'd taken you to that part briefly, page 303, under the heading Retained EU Law, where the different arguments are set out.
Ladies, as I understand it, the
Yes.
issue was that because what had happened was that there were immigration rules effectively enacted to enable the Rwanda scheme, and so they'd been enacted not to import EU law, but EU law was relied upon as a basis for saying they were unlawful, and that's why there was the reliance on Section
Okay,
4,
got it.
because you had to rely on the underlying.
Yeah, no, that's very helpful. Thank you.
Those are the relevant parts from that particular decision.
So how would you deal then, Mr. Kinnear, with the point that Mr. Southey's just made, which is, I think, that there's a distinction between what was going on in this case and what's going on in this our case, which was that what was at issue in AAA Syria was new immigration rules which were brought into force after the 2020 Act and which were said to be unlawful because they were incompatible with retained EU law. Whereas at the moment I'm not clear whether there are any new immigration rules at issue in this case, or whether we're just looking at, which is one of the reasons why I wanted to know what immigration rules we're dealing with, whether there are any immigration rules that are materially different which applied at the relevant time from the immigration rules that were said to implement the qualification directive. Sorry, that wasn't at all a clear question. I don't know if I got the drift of it.
I may be able to answer it if you turn to the tabs that we inserted today at tab 11 on U11A and B.
Yeah.
And if we look at this point in particular in relation to 339AC, we can see behind tab 11A,
Yeah.
those are the rules that were in force just before December of 2020, and you can see in relation to 339AC, it says that this paragraph applies with the Secretary of State has satisfied that, and then one, there are reasonable grounds for regarding the person's danger to the security of the United Kingdom. The only amendment to that in terms of 339AC1 is if you turn then to tab 11B and find that rule again, which is on the 4th page of that tab under the heading Danger to United Kingdom. You can see that by June of 2022 the words Article 33(2) of the Refugee Convention had been inserted into that rule. That's the only material change.
This language is pretty much identical to the qualification directive.
It is, and I'm going to look at that under the next heading, if I may.
And 2006 qualification regulations, which are said to be part of the way in which the qualification directive was implemented, when were those repealed?
Those were also repealed. I'll have to check it over lunch, but I think from recollection again it was the 31st of December of 2020.
Right, because by the time we're in 11B, there is what is potentially a material difference between, we've only had a quick look, 339AA in the two versions, because in the version in 11A, 339AA refers to the 2006 qualification regulations, whereas by the time you get to 339A in the second version, that reference has been deleted.
Yes.
Okay. Are there any other references in the first version to the 2006 regulations which have been deleted by the time you get to?
Yes, I believe there are. If you turn, for instance, to 334 is exactly where I was taking to.
That refers
at little Roman numeral 2. It refers to the qualification regulations. In the revised versions, it
doesn't.
It doesn't. Well, it's amended to Article 1 of the 1951
Yes.
Refugee Convention. Yes, I'm grateful. It's actually in the footnote to one of our documents. I'm grateful to Ms. Parsons. The qualification regulations were revoked by Section 30, subsection 4 of the Nationality and Borders Act 2022, with effect from the 28th of June 2022, which makes sense if you turn to the first page of tab 11B. You can see that those are the version of the immigration rules valid from that date, from the 28th of June 2022.
And were there any saving provisions when this version of the rules was introduced? Because the general rule is immigration rules take effect from the date of the statement of changes, but sometimes the statement of changes makes express transitional provision. Was there any express transitional provision in relation to these changes?
I'm not aware, my lady. Again, that's something we'll check that.
If you could check that, please, that would be very helpful.
But do any provisions of the qualification regulations make any difference in this case?
No, in our submission, no. Can I just check, unless there are any other questions in relation to that particular limb, I'll move on to the second limb.
Yes.
The second limb effectively is that, as I said in my introduction, that the two decisions, the revocation and the refusal of asylum, were not decisions to refile, and effectively that the case of T had no relevance. And we submit there was some confusion by the Commission in respect of the application of Article 21, when we would submit that the correct article for consideration was Article 14, and that has always been the Secretary of State's case, and to make good on that submission, could I invite you to have available the supplementary bundle, please? there are some submissions that were made by the Secretary of State. Just to put this in context, there were a huge number of issues in this case, and some of them crystallised towards the end. And having made oral closing submissions, the Commission invited further written submissions in relation to various issues that are set out in these submissions, and there are. This is a response to a document provided on behalf of DA, and in fact there's a response to this document as well. But just in relation to the Article 14 point, if I may, at page 51, so paragraph 2 of the bundle, we set out the revocation was on the 15th of October, that the reason for the revocation was reasonable grounds for regarding DA to be a danger to the security of the UK. And then the same basis for revocation is set out in Article 14.4 of the Qualification Directive. We'll look at it in a moment, to which the immigration rules give effect. The wording derives from Article 33.2 of the Refugee Convention. So that's the first mention of Article 14. Then please, at paragraph 4, it is important context to this response to note that whilst the revocation decision and the asylum decision adopt the wording of Article 33.2 of the Refugee Convention, neither decision is a refoulement decision. And then after the passage in brackets, they were respectively a decision to revoke his refugee status, which does not equate to a refoulement of a refugee, and a decision to refuse his asylum claim, which similarly does not equate to refoulement of a refugee. And then at paragraph 10, T did not consider the revocation provisions in Article 14.4 and 5, the material provisions in DA's case, nor the meaning of test reasonable grounds for regarding the person to be a danger to the security. So in our submission it was clear that the issue of Article 14 versus Article 21 was a live one. We've already looked at the notification letters in tabs 11 and 12. And can we look now, please, at the Qualification Directive itself, which you will find in the Authorities bundle behind tab 8, starting at page 27. So, first of all, at a high level, I'll give you the reference again, my lord. It's Authorities Bundle, tab 8, at page 27. So, on the right-hand side of page 27, we can see Article 14, which, as I've said, at a high level, relates to revocation of ending off or refusal to renew refugee status. And then on the page 28 towards the bottom and the left-hand column, we can see Article 21, which is entitled Protection from Refoulement. So in our submission, those are two different concepts, though a similar test applies. Though again, importantly in our submission, as we look at the authority of the case of T, the consequences in our submission of refoulement are obviously likely to be more severe than that of revocation. Now, if one looks at 14, Article 14.4, you can see it states, member states may revoke, end or refuse to renew the status granted to a refugee by a governmental, administrative, judicial or quasi-judicial body when A, there are reasonable grounds for regarding, emphasise that word for the time being, for regarding him or her as a danger to the security of the member state in which he or she is present. That is identical wording. That wording is identical to that contained in Immigration Rule 339 AC little 1. And Article 14.4b mirrors the wording in Immigration Rule 339 AC Roman numeral 2. It's really the first that we're concerned with here, so Article 14.4a. The like provision in Article 21 is in Article 21.2a. So 2, where not prohibited by the international obligations mentioned in paragraph 1, member states may refile a refugee, whether formally recognised or not, when A, there are reasonable grounds for considering him or her as a danger to the security of the member state in which he or she is present. So the wording in 14.4a and that in 21.2a is very similar, save that the word regarding is replaced with the word considering in 21.2a. We haven't been able to find any authority or reasoning why the two different words are used. We've looked at some of the other language versions of this, and in some of them the wording is the same. But I think obviously in the English one, the English translation is different. But we would submit that regarding and considering really have exactly the same meaning.
I think it would be helpful, Mr. Kinnear, since Article 13, which we have got on page 27, helps us to understand the concept of refugee status, but it does say by reference to chapters 2 and 3, which we haven't got. So if we could please be provided with copies of the provisions of chapters 2 and 3, so that we understand what the concept.
We'll print the whole thing off. I apologise. It's always there's always
it's always very
the
difficult.
tension between trying to keep
I absolutely understand that, and I'm not criticising you. I think it just because there is this reference to the concept of refugee status. We don't know what it is.
Miss Parsons is way ahead of me because she's already brought it.
Oh right. That's very helpful. Thank you.
Thank you very much.
Lindsay, your submission is that there's no difference between regarding and considering.
Yes.
I doubt that's controversial.
I don't think that's controversial. No.
But you nevertheless say that the two provisions ought to be interpreted differently as
Yes.
much as the EU law.
Yes.
Thank you very much. And to spell that out, the reason is that if you were refouling someone, then according to T, you should be doing that as a matter of last resort. But we're not concerned with refoulement, we're concerned with Article 14, and it's not a matter of last resort because you're not refouling the person.
That's correct.
Yeah.
And a further distinction is that 21 is qualified by other international obligations, whereas I don't think 14 is it?
No, and in fact, sorry, the other point in relation to 14 is if you look at 14.6, so persons to whom paragraphs 4 and 5, so paragraph 4, danger to national security applies, that you are still entitled to the rights set out or similar to those set out in Article 3, which is more favourable standards, in particular Article 16, which is access to courts, Article 22, which is access to education, Article 31, which relates to access to accommodation, Article 32, and Article, and in fact Article 33, which is obviously the refilement provision. And so in our submission, under the consequences of being refiled under Article 21 is a severe consequence, and as we see in T, a matter the European Court have said is a matter of last resort, whereas the situation in relation to Article 14, although the test is the same, the consequences are much, much less severe, because the person to whom the decision, in relation to whom the decision has been made, is still entitled under 14.6 to all of those additional protections.
Now, is that still the position under the immigration rules? So if your refugee status has been revoked, or your claim has failed because you could be refiled, are you still entitled to all those benefits here?
We submit yes, because if we are
Well,
wrong,
it's not a matter of submission. I mean, is that what the Secretary of State does?
yes.
All right. All right. Thank you.
So, this is something I find quite confusing. So the fact that your status as a refugee has been revoked doesn't mean you cease to be a refugee. Is that right?
I think you cease to be a refugee, but you still retain those core rights that are set out within Article 14.6, such as the one that I referred you to was education, which presumably relates to a person under the age of 18 who, although their refugee status has been revoked, they're still entitled to education in this country until such time as they are removed. Likewise, all whose refugee status has been revoked are still entitled to access to the courts.
And the Qualification Directive appears to make a distinction between refugee status, which is a thing that's granted by member states pursuant to Article 13, and being a refugee, which is referred to in in Article 12, third country national status person excluded from being a refugee. And we haven't got the rest of the relevant provisions, but it may be that there's a distinction between meeting the definition, being a refugee, and being entitled to refugee status, which is in accordance with chapters 2 and 3, which we haven't got.
My lady, yes, but that indeed may be right. But in our submission, the core point here is difference in consequence between.
No, I've got.
Yes.
Yeah, I understand that. Yeah.
So the grounds for excluding somebody from being a refugee in 12.2 do not include being considered to be a danger of security of the member state.
No, because effectively the reasons, when we look at the decision in T, the reasons why the court says that 21 is a matter of last resort is because if you find someone to be a danger to national security, you could effectively be returning to a country where they are in danger.
Just going back to my Lord's question, Article 12, I think, deals with the express exclusions from the protection of the Refugee Convention, which are dealt with in Article 1, the D or C of the Refugee Convention, which is different from the grounds on which you can refoul somebody who meets the definition of refugee.
Yes.
Could I ask, in that regard, in the authorities bundle, I think tab 12, the index suggests that we have Article 1, but I don't think we actually do in tab 12.
We've got that as well. That was meant to have been in there and was missed off. I'm afraid they're not hole punched.
once again, it's the tension between economy and bundle size, and enabling
It
those
is.
of us who aren't familiar with these provisions to look at them.
Yes.
Because I don't imagine there are very many people who've got the provisions of the Refugee Convention in their head.
So I think Article 1, definition of the term refugee, and of particular relevance may be F. Provisions of this convention shall not apply to any person with respect to whom there are serious reasons for considering that A, he's committed a crime, B, he has committed serious non-political crime, C, he is guilty of acts contrary to the purposes and principles of the United Nations. And we submit, my lord, that the issue is that the Commission's judgment focuses in on Article 21 from paragraph 171 onwards, and I'm going to come back to them in a few minutes, that gives no real or proper consideration to Article 14. And in fact, the only mention to Article 14 is a footnote, which you will find the judgments in the core bundle behind tab 7. Page 96 in that bundle.
I'm so sorry, could you say the paragraph again, please?
Yes, sorry, the page is page 96. And it's relating to paragraph 132, which in fact starts on the previous page, where the Commission is setting out some of the relevant immigration rules. So at the bottom of 95, they set out 339A, A, and AB, and then over the page, the top of page 96, Commission sets out this paragraph applies with the Secretary of State is satisfied. It's the effectively from the immigration rules, paragraph 339 AC1, and then there's a footnote to that at 7, and it says this gives effect to Article 14.4 of the Qualification Directive, which reflects Article 33.2 of the Refugee Convention.
You agree with that?
We do agree with that.
Yep.
But that's the only consideration in the only mention, in fact, of Article 14 within the judgment. And the rest of it effectively, I want to look at T first of all and then come back to the judgment. But the Commission's judgment focuses on 21, when in our submission and our case was at all times that this was an Article 14 case, not Article 21. Could I, before returning to the judgment to look at the relevant paragraphs, could I take you first of all to the decision in T, which is obviously in the authorities bundle, tab 26, please. starting at page, first page is page 572. And the report has firstly the opinion of Advocate General Sharpston starting at page 575, which I just want to look at firstly because the Commission refer to it in its judgment. Starting, if I may please, at paragraph 21. This is under the heading of the Common European Asylum System and Qualification Directive above paragraph 12. So Advocate General Sharpston is setting out effectively a summary of the Qualification Directive and its relevant provisions. And at paragraph 21, she deals with Article 14. Member States may revoke and or refuse to renew refugee status where the conditions in Article 14 are met. In particular, they may do so under Article 14.4 when there are reasonable grounds for regarding the refugee as a danger to the security of the member state in which he is present, or irrelevant for these purposes, the second part, 14.4b. So that's her citing Article 14. At paragraph 46 of her opinion, she sets out what the issues that were being considered were. There is a degree of overlap between the three questions referred. I understand the essential issues to be first, whether a resident permit once granted may be revoked. That's under Article 24. Where there are either compelling reasons of national security or public order under Article 24.1 of the Qualification Directive, or grounds for applying the exception to the principle of non-refoulement under Article 21.2, or 2, only where there are grounds for applying the exception to the principle of non-refoulement under Article 21.2. Second, if the answer to the first question is Roman numeral 1, how should the phrase compelling reasons of national security or public order in Article 24.1 be interpreted? So those are the issues. So it's clear in our submission that although she cited Article 14, the interpretation of Article 14 simply wasn't an issue in T at all. And then forward, please, to paragraph 77. Which is under the heading on the previous page, bottom of 591, what is meant by the exception in Article 24.1 of the Qualification Directive. And she says, 77, it seems to me that although Articles 21 and 24 give rise to different regimes, there is indeed an overlap, inasmuch as both provisions concern the refusal to grant, revoke or renew a residence permit and has implications for his status in the member state where he seeks protection. So again, you might take that conclusion or that opinion through, that there is some overlap between 14, 21 and 24, but only some in our submission. And then over the page, please. Paragraph 81. My starting point is the principle contained in Article 21.1. Refugees are normally protected against refoulement. I'm not going to read the whole of that paragraph out, but if you go down, I think, to the 10th line, middle of the line, after where it states Article 212b, she states the consequences for the person concerned of applying the Article 21.2 exception are potentially very drastic. He or she may be returned to a country where he or she may be at risk. And that's repeated really at G. Potential consequences for a refugee of finding oneself after application of Article 24.1 without a resident purpose are certainly undesirable, but they are much less severe than the consequences of having lost one's protection against refoulement. And again, in our submission, Article 14 lies much more in line with Article 24 than it does with 21.
Well, except it uses the same words.
Yes, I accept that.
And here the distinction is drawn between the wording.
Yes, I accept that, my lord. At 82, she looks at Article 14. It is further light rather than further confusion and darkness shed by looking at other provisions of the Qualification Directive. For example, by bringing Article 14 into the equation. And then at 83, Article 14.4 sets out the two possible conditions under which member states may revoke and or refuse to renew the status granted to a refugee by a governmental, administrative, judicial or quasi-judicial body. Those conditions which appear without conjunction do precisely mirror the two limbs of Article 21.2, exception the point that my Lord Justice Phillips just made. So far so good, but that parallelism does not assist in deciding how to interpret Article 24.1, which is about residence purposes for persons who retain their refugee status, and then she makes a comment about something that she'd hoped was going to be done but hadn't. And then at paragraph 84, against that background, I do not consider it to be particularly fruitful to focus upon the words reasonable grounds for Articles 14.4 and 21.2 as against compelling reasons of Article 24.1. Each expression should be read within the context of the provision of which it forms. It is necessary to look at the wording of each exception in its entirety, and as an exception to rights guaranteed by EU law, each should be interpreted narrowly. So in our submission, first of all, she's not dealing with Article 14 in any detail, but secondly, she is saying that you have to look at each of Articles 14, 21, 24 in the context in which they sit in EU law, which in our submission includes the consequences of a decision made pursuant to each article.
I mean, she doesn't really answer the question she poses at paragraph 82, does
No.
she? She, having raised it, she then goes on to say that 21 and 24 are different.
Yes.
Is that right?
And then, if we can then move forward to the judgment of the court itself. That starts, just for your reference, at page 603. But the relevant parts really start at paragraphs, the most relevant parts are paragraphs 68 through to 75. At 68, which is at page 616, Articles 21.2 and 24.1 of that directive constitute, in that regard, the implementation in positive law of the rights conferred on every person by EU law with a view to ensuring lasting protection for him or her against persecution. At 69, the last sentence, the court's looking at differences between 21 and 24. It is nevertheless settled that those provisions have distinct scopes and pertain to different legal regimes. 70, Article 20...
And you say, pausing there, that logic should equally apply to Article 14.
Indeed, yes. And at 70, Article 21.1 of Directive lays down the principle that refugees are normally protected from refoulement. So it's specifically looking at the issue of refoulement. And then at 71, 71, the refoulement of a refugee while in principle authorised by the derogating provision, Article 21.2, is only the last resort a member state may use where no other measure is possible or sufficient for dealing with the threat that refugee poses to the security to the public of that member state. Now, when we look at the Commission's judgment in a moment, you will see that they cite paragraph 71, but they stop in the middle. They stop at the end of the word "to the public of that member state." And the next bit in our submission is important, which states, in the event that a member state pursuant to Article 14.4 of that directive revokes, ends or refuses to renew the refugee status granted to a person, that person is entitled, in accordance with Article 14.6 of that directive, which I took you to rights set out inter alia in Articles 32 and 33 of the Geneva Convention. So if you're revoked under Article 14, effectively that's the first step. Your refugee status is revoked, but you retain the protection, in particular of Article 33 in relation to refoulement. And then at 72, the court really echoes that which Advocate General Sharpston had set out. The consequences for the refugee concerned of applying the derogation provided for in Article 21.2 are potentially very drastic, as Advocate General Sharpston noted in point 81 of her opinion, since he might be returned to the country where he is at risk. And then the next part in our submission is very important as well. It is for that reason that the provision subjects the practice of refoulement to rigorous conditions, since in particular only a refugee who has been convicted by final judgment of a particularly serious crime may be regarded as constituting a danger to the community of that member state within the meaning of that provision. Moreover, even where those conditions are satisfied, refoulement of the refugee concerned constitutes only one option at the discretion of the member states, the latter being free to opt for other less rigorous options. And again, over the page at 74, the consequences for the refugee of revoking his residence permit pursuant to Article 24 are therefore less onerous insofar as that measure cannot lead to the revocation of his refugee status, and even less to his refoulement within the meaning of Article 21.2 of that directive. So, I mean, if you were putting the directives into a league table, 21's obviously the most serious, 24 the least serious, and 14 sits somewhere in the middle. We would submit that's the import of this decision. And then 75 follows that the concept of compelling reasons contained in Article 24.1 has a broader scope than the concept of serious reason contained in Article 21.2, and that certain circumstances which do not exhibit the degree of seriousness authorising a member state to use the derogation provided for in Article 21.2 of that directive and to take a refoulement decision can nevertheless permit that member state on the basis of Article 24.1 of the same directive to deny the refugee concerned his residence permit. So, in summary, first point, we submit this case is not to do with Article 14, T's not to do with Article 14, and our case is an Article 14 case. And that the position that the court took, the European Court took in relation to T, and the additional balancing exercise was imposed because of the serious impact or consequences of a refoulement decision in particular.
But the balancing exercise that SIAC refers to is at best implicit in what the court says about refoulement, because there isn't an express discussion of balancing refoulement with other measures. You know, the expense of surveillance and all the rest of it. It's just left open.
It's a measure of last resort.
Yeah, that's all they say.
Yeah. So can I move then from T back to the judgment of the Commission, if I may, back to the core bundle.
Well, just show us where in T we get the concept of last resort. I don't think we've seen it in the paragraphs, have we?
71.
It's 71.
Yes, but that's as applied to refoulement.
Yes.
But there's no mention of last resort in relation to Article 24.
No.
No.
That's the point I'm making, and my point is that Article 14 sits, most certainly we would submit, somewhere in between in terms of seriousness. The stance taken by the court in relation to Article 21 is so extreme, if I can call it that, because the consequences of refoulement are so extreme. So back then, if we can please, to the judgment of the Commission, tab 7 in the core bundle, starting at page 104. We'd already looked previously at 168 through 170. I'm not going to go back over them again. Paragraph 172 is the citation that I mentioned. And you can see that paragraph 71, citation of paragraph 71, leaves out the end of paragraph 71 at page 616 of the authorities bundle. And as I've already submitted, that part is important because it demonstrates that if refugee status is revoked pursuant to Article 14, then the protections contained in Article 14.6 are engaged, which in turn in our submission makes good that there's a qualitative difference, although the same wording is used in 14 and 21, that there is a qualitative difference between the consequences of a decision made under the two different articles. 173, the Commission states that T is binding upon it, and there's some dispute on whether the Commission was saying it was bound by it or not, because elsewhere it states, I think it's at paragraph 192, it states that T is merely highly persuasive. But in our submission it doesn't really matter because the approach that the Commission took was wrong in any event. I mean, my ultimate submission in relation to this is that T isn't relevant at all and that the Commission should have approached this exercise through the prism of Article 14 rather than Article 21. Paragraph 178 is effective enough. It's looking at the connection between Article 21 and Article 33.2 and the immigration rules. So 4 lines down. However, the issue is whether the exception in Article 21.2a of the Qualification Directive, based as it is in Article 33.2 of the Refugee Convention, and the relevant immigration rules in which the direction is based, themselves framed as exceptions to a general principle, permits the refoulement of someone who would or might otherwise qualify as a refugee. So it's clear in our submission the Commission is proceeding here pursuant to Article 21. The Secretary of State successfully defends the revocation of asylum appeals on the basis that the national security exception applies, and in any future proceedings assailing the lawfulness of D8's physical removal from the United Kingdom, it would not be open to D8 to relitigate this issue. But in our submission, if the test is different, then it would be reopened to D8 to relitigate the issue. So if he was going to be refiled, the test, if T is right, but for our purpose it doesn't matter whether it's right or not in relation to Article 21, because we say it's a Article 14 case, then D8 would be entitled to have his case tested against that test, rather than that which we submit Article 14 requires. 179, we submit that this error carries over into 179. States it follows that in our view, Mr. Kinnear is seeking to draw an artificial distinction based on form rather than substance. In any event, the accuracy of his submission may be tested in a different way. In proceedings which were directly concerned with the summary removal of D8, the logic of Mr. Kinnear's stance is that the true construction of the relevant provision should vary. It would be strange indeed if the true construction of Article 33.2 read in conjunction with Article 21 could vary according to the context. It should bear one interpretation if refoulement were directly in play and another if it was not. But in our submission, that's not right. There was no circularity or artificial distinction in our submissions. We were saying this is an Article 14 case, and the test is different. And as I think we discussed previously,
the test for what is different? Whether somebody is a danger to national security, or whether there are compelling reasons? What is it?
Well, the
all about?
the Commission's decision in D8's case was that the national security limb was not made out because the Secretary of State had not carried out the balancing exercise, and therefore it concluded on that basis that it couldn't reach the conclusion that he was a danger to national security. I mean, we submit that's a rather we submit that the reasoning doesn't make sense, particularly when you consider it in the prism of Article 14.
How does it work then under the approach of the court in Ray T if there's a decision that the refugee constitutes a danger to national security, but they then have a balancing exercise and look at how does it work under Article 21? Do they decide at the end of the day that they do not pose a danger to national security, or do they say they rely upon the permissive aspect of the article?
Well, that's why this case is important, because it's not a point that's arisen previously.
I'm asking for your submission on what do you say is the approach under Article 21?
What should the approach under Article 21 be? Well, our primary submission in relation to that is that this court shouldn't be concerned with that, because it's not an issue that arises in this case.
No, I think what I'm asking is what do you submit that the European Court of Justice was saying the approach is in Ray T?
Well, they were saying, I would submit they were saying that there has to be some sort of heightened exercise, though of course they don't say exactly what that should be. In relation to Article 21 and refoulement.
But there are two things they might have said. One is that because it is not a last resort, i.e. there are ways of managing the situation, he doesn't present a danger to national security. Or they might have said that he does present a danger to national security, but because there are ways of managing the situation, there are not sufficiently serious reasons to refoul him.
Yes.
Now, which of those, or any third possibility you might want to suggest, are they saying?
Well, we would submit it's not entirely clear. Certainly what the Commission is saying has to be done is there has to be that exercise of weighing up the danger aspect against the cost, practicability, etc. of managing that danger, i.e. before you refile, you first of all look at the danger, how dangerous, I don't know, it's meant to be on a scale of some sort, you measure them 1 to 10, then you look at how much it's going to cost. For instance, if someone's at 8 on the scale, presumably they might have to be subject to 24-hour surveillance or other measures. We would submit this is one of the difficulties with it. It's impossible to judge.
Well, one problem with that is that you can put 24-hour surveillance on somebody and enormous resources, and you're not surveying one of the many other people
Exactly.
who are posing a danger to national security. I mean, the European Court didn't really go into that.
No.
But what is their? But I'm asking you, what do you say is their analysis out of the two possible analyses that I suggested to you, or if it's something else, then tell us what they're saying.
Well, I'm not sure I'm able to give you an interpretation of what
But
the
they
European
didn't need to
Court
give guidance on 21 because they were just contrasting 21 with
the 24.
24.
Yes,
So-
it wasn't even a 21 case. T.
No, that's the point. So
Yes.
what they say about 21 is kind of obiter,
Yes.
if that concept exists in EU law, it probably doesn't. But there was no need for them to go any further than they did because they weren't concerned with an Article 21
Exactly.
case.
Which is the point I make in this case as well. If you come to the conclusion it's an Article 14 case, then T isn't relevant at all. And there's no need to go on to consider what the test in Article 21 is at all.
The Commission at 283 concludes that the Secretary of State has not addressed the terms of Article 21 of the Qualification Directive, and insert there, except you say it's Article 14, not 21, in the manner glossed by the CJ, EU and T. I think the question is, what is the gloss that the Commission, well, what is the gloss that the Commission thought was put on T?
Well, I'm going to go through some parts of the judgment now, so can I take you through the next few paragraphs of the judgment?
Well, you can, so long as you don't forget my Lord's question, because I think we would like to know the answer to it when you get there.
Yes. Well, I think when we look at the judgment, we're going to see how the Commission treated T.
Okay.
I think my Lord already has identified that paragraph 283, which is the reason why I took you to that right at the beginning of my submissions. Because at 283, as I submitted before, what we submit the Commission means here is that because the Secretary of State hadn't conducted what the Commission, what I'm now describing as the balancing exercise, because the Secretary of State hadn't conducted that, effectively there was no way that it could make a finding or uphold the finding that D represented a danger to national security. As it says there, whether D represents a danger to national security, she has not addressed the terms of Article 21, the Qualification Directive. And as it rightly points out, Mr. Kinnear did not submit that she had. She hadn't. We were submitting it was an Article 14 case. And his argument was that T had no relevance.
Is it paragraph 190 of the Commission's judgment where they...
Yes, my Lord, in relation to paragraph 90, they return there to T and its application. And it says, that's where they talk about last resort. So at 190, of more difficulty for Mr. Kinnear is the judgment in T that Article 33(2) is a measure of last resort and should only be applied when no other measure is possible or sufficient for dealing with the threat.
But the CJU wasn't talking about Article 33(2)
No.
directly, it was talking about Article 21.
Indeed. Though both relate, there is the nexus that both relate
Sure,
to the refoulement.
But the CJU was concerned with the interpretation of Article 24, and in interpreting 24 it said a bit about 21.
Yes.
So it seems to be the case that the SIAC analysis, which you say is wrong, is that somebody is not a danger to national security if the result of the balancing exercise is that whatever risk they present can be managed.
In the refoulement context, yes.
Well, no, their analysis, which is what you say is wrong, is that is what danger means. See the conclusion at 286, which is consistent with 190. Danger is a matter of fact and degree, and you say they got that wrong.
Yes.
Because they applied a refoulement analysis where that was not appropriate.
Yes. But then if you go back as well to 282, which again I took you to previously, where they say if we had concluded that Mr. Kinnear's submission on the law were correct, we would also have concluded the national security case was made out. So it's the injection of the balancing exercise.
That's a decisive point.
Which turns the assessment that D8 is a danger to national security into an assessment that he's not a danger to national security.
But this proportionality analysis is an invention of commissions, isn't it? Because there's nothing in, or is there anything in T which talks about proportionality or balancing?
No.
Because I hadn't detected that there was. I just wanted to be sure that I hadn't missed something.
Well, it's all based upon the paragraph where they introduce the idea of last resort and then contrast it with Article 14.
Yes. And then we've looked at paragraph 190, at 192, which is page 109.
You need to look at 191, don't we?
Of course.
They say Article 21.2 impose on the Secretary of State a more onerous standard.
Yes, well, I mean, again, that's back to my basic point, that again, it's looking at the whole thing through the prism of Article 21 rather than Article 14 as we had submitted.
Because Article 21 is especially referred to in that paragraph.
Yes.
Yeah.
And I've made the point already that 14 isn't referred to, other than that one reference in footnote 7. And then obviously 192, it states that come to the conclusion that paras 68 to 75, which are the precise paragraphs that I took you through in T, are highly persuasive and should be applied to the present case. As we have explained in T, the CJ EU carried out a close, compelling comparison between Articles 21 and 24.
Sorry, what paragraph are you reading from?
192, my lord. Bottom
Yes.
of page 109.
Yes, got it, thank you.
And they say, although not necessarily binding, we see no reason to disagree with the CJEU's reasoning and conclusions in relation to Article 21, so closely bound up as they are with its analysis of Article 24. In particular, there is no answer to Advocate General Sharpson's analysis supported by the CJEU, highlighting that the degree of risk or danger to national security required by Article 21 must be greater than that contemplated by Article 24. I'm not sure that even correctly summarises in our submission what the position was. This is because the consequences for the refugee are more serious in an Article 21 case. It follows that in an Article 21 case what is required is something greater than compelling reasons of national security. Um, 193, effectively the Commission identifies, I may call it this, a point against itself, that it identifies that the test in relation to the deprivation of a person's citizenship under Section 40 of the BNA 1981 would effectively mean that there were two different tests. Again, that wasn't, as the Commission identified, that wasn't a point that I took in the case, because we were wedded to the position, the Article 14, and the lack of relevance of T. And then 194, again, is back to a paragraph I took you to at the beginning, which is effectively in our submission, follows that the Secretary of State must balance the degree of danger to national security, assuming that it is possible to assess it in the circumstances of an individual case, and particularly so it is being assessed against the cost, practicability and feasibility of any measures that may be taken to ameliorate the risk, and must demonstrate that she has regarded the Article 33(2) exclusion as a measure of last resort.
So what the sentence starts with, it follows that, but it follows from what?
Well,
because the fact of the balance of the danger of national security against the cost and so on, that's just popped up out of nowhere.
my lady, yes. I mean, our submission, this part of the judgment, errs in law. For all the reasons I've already given. I mean, it's very difficult for me to put myself in the mind of the Commission exactly why they've said what they did or approached it in this way. Not least given that our submission, as I took you to, was very clear in relation to this.
I mean, it's a bit odd in a way that they say that the Secretary of State must do something, i.e. balance the degree of danger to national security, assuming that that is possible. I mean, until they know whether it's possible or not, it's a bit hard to say that he's got to do it, isn't it?
We would agree. And then, really finally, paragraph 195. They state, finally, the approach of the CJEU&T is not, we think, inconsistent with Begum in the Supreme Court and what may be described as the post-Begum line of authority. And at the end of that paragraph, as we've already said, the overall approach in Begum applies to the Commission's appellate function, subject to our being satisfied that the decision maker has at least addressed and considered what Article 21 requires. Again, it's nebulous and in our submission is wrong in any way.
If the balancing exercise is required, what is the role of the court if the Secretary of State carries out the balance? Is the court considering that for itself on appeal or applying some kind of rationality test? And in either event, does that involve, I say the court, I mean SIAC, does that involve SIAC in reaching a decision for itself, which may differ from the Secretary of State's, about how serious the danger to national security is?
We submit that the Commission should not be carrying out that task for all of the reasons set out in the authorities Raymond and Begum.
But I mean, if the balancing exercise is the test, does that not necessarily bring SIAC closer to what you say is forbidden territory?
Well,
which might be a reason.
I hadn't given that any consideration, but yes, I think that would be a reason why this is a balancing exercise that shouldn't be carried out.
I have a feeling that somewhere SIAC had said that the question for them was whether the Secretary of State had done it, and if the Secretary of State hadn't done it, that was enough. But I can't remember where.
Yes, it does say that. I mean, it hadn't been done. I accepted that that exercise hadn't been done. It does say it in the judgment.
So I'm not sure that SIAC necessarily grapples with. I might be wrong because I might have.
Wasn't it the last sentence of 194?
Let's have a look.
Yes. And the Commission should be driven to conclude the Secretary of State's conclusion as to danger to national security is flawed.
Right.
So, I mean, I conclude there by saying far from even being persuasive, T was simply not relevant, and the Commission approached the case through the prism of Article 21, and it should have done so so through the prism of Article 14. And for all those reasons, we submit this appeal should be allowed, and D8's appeals against the revocation of his refugee status and the refusal of his asylum and humanitarian application should be dismissed.
Thank you very much, Mr. Yeah. Yes, Mr. Self.
Thank you, my lords and my lady. Obviously, the issues in this case arise from the approach of SIAC. Our starting point is that in terms of the issues under the 2018 Act, the approach of SIAC was entirely correct, which was to, we would say, and you see this, I think it's at paragraph 192, it was to regard T as persuasive, goes no more in our submission. It was to treat, as Lord Justice Phillips pointed out, it was to interpret the rules so far as possible consistently with the qualification directive. It regarded T as binding in relation, we would submit, to the issue of EU law T was deciding, but the reason it regarded it as persuasive was because it recognised, we would submit, that T wasn't obviously directly determining Article 21 or indeed Article 14. That isn't consistent with, that isn't inconsistent rather with paragraph 170, which is what my learned friend pointed to, and the reference to retained EU law, because, as the Commission made clear, it was relying on Section 2. And I'll come on to why we say Section 2 is relevant. My learned friend also, a moment ago, raised the issue, while we've got the judgment open, but it may be worth having this in mind when I go on to some of the more detailed parts of my submission, the application of the proportionality test that one sees in paragraph 190 and 194. To be clear, what we say in relation to that is that not just T, but in fact UNHCR, and that may be an important starting point, recognised the last resort test in relation to both Article 21 and Article 33 of the Refugee Convention. If you start with the issue of the last resort test, in our submission, that has two possible consequences. One could say, if it's a last resort, any measure, no matter how sort of cripplingly expensive, no matter how difficult it is to implement, could prevent refoulement. Where in my submission, SIAC perhaps sensibly went, and we don't challenge this, is to say, well, of course, even if it's even if you're looking at last resort, you do have to look at the practicalities of it. And so it is in one sense qualifying T, because you could say T actually went further. It's difficult to see what either a last resort is the only practical solution, or it's the only solution. It's difficult to see what else it could mean. And SIAC, we would say perhaps sensibly, ultimately opted for the only practical solution.
But Ray T expressly contrasts the last resort in Article 21 with Article 14, which is not the last resort.
It doesn't expressly, I'll come on to what it says. I wouldn't accept contrasts it with Article 14. My Lord, there is a reference to Article 14, and there's a reference to the fact that Article 14 continues to preserve Article 33.
No, 14.6
It refers to Article 14.6, but my Lord, the contrast is with Article 24. If one, as my Lord's asked the question, why not, rather than me park it, it's at 616 and 617. And my Lord is right, and I don't think I said anything inconsistent with that. I think I acknowledged it. That at paragraph 71, the last resort test is applied to Article 21.2, the directive. What follows is what might be said to be a slightly more opaque statement about Article 14.4 and the preservation of Article 14.6 and preservation in Article 14.6 of the rights, particularly the right in...
Well, am I wrong in reading that as a contrast?
Yes, my submission, it isn't a contrast. What it's saying, what we would submit that seeking to recognise is the fact that there is obviously a relationship between the language in Article 21.2, the language in Article 14.4, and the language of Article 33, all of which essentially use the same terms. As my learned friend, there is one minor term difference in the English language version, but nobody suggests that makes any difference, and Advocate General Sharpston expressly recognised that it didn't seem to make any material difference. But I come back. Can I come in one sense? Can I come back to it? Because I mean, one of the key questions is if, and this is perhaps a more important starting point for T, if there had been if it was intended that there was a different approach to Article 14 in Article 14 to that in Article 21, why use exactly the same language and the same language as it reflects Article 33? The one thing that one gets from Article 24, from the consideration of Article 24, that this is perhaps the clearest principle one gets from T, is that if the EU wanted to adopt a lesser test, which it clearly did in relation to Article 24, it adopted different language. But we do submit, because in one sense it is the starting point for all of this, because it's where the language essentially derives from. The starting point is the Refugee Convention, in part, and this isn't something my learned friend has touched on, perhaps understandably, in part because what UNHCR have said about the Refugee Convention and what they've said about the particular language. The Refugee Convention, Article 33, is in the authorities bundle at page 39. And to put this in context, and it may matter this, because in one sense it sort of is the context in which both the immigration rules and Article 14 and Article 21 need to be considered. Nothing, as far as I can see in the Refugee Convention, entitles a person to any leave within the UK. The Refugee Convention is about fundamentally
reform on and protection. That's what Article 33 in particular is concerned with. There are provisions, for example, about the need to, clearly an objective of the Convention is to integrate people who are refugees, but there's nothing in the Refugee Convention itself that says an individual has to be granted leave within the United Kingdom.
But there are lots of provisions which have, I mean, which in effect say you've got to treat people who are refugees here as if they can benefit from, you know, right to work, security benefits, education, all the rest of it. I mean, they're all missing from the clip we've got. But
well, absolutely, my lady, and that's why I was going to go on to say that of course, in a modern society, the way one implements that is by giving someone some form of status, and that's why EU law provides for the status. That's why domestic law provides for the status. It's difficult to see how within a modern society where, probably globally, people's access to various things like education depends on their status within the country. It's difficult to see how you can implement that without giving status. But it's still an important part of the context because it explains in one sense why, or it's part of the background to why you then have...
There's also a right to a travel document as well, isn't there?
There are, yes. But my lady, the point, the reason I'm drawing attention to that is not to say that in a modern society there's no sort of, this is a purely domestic concept. It's clearly not purely a domestic concept, the grant of leave. It's a way that you implement it. But the reason I'm drawing attention to it is that it clearly meant that when both EU law and domestic law was adopted, there was a need for consideration, essentially, as to what tests should be applied for revocation, because there was nothing in the Refugee Convention that expressly governed that. And that's the context, and that's important because the language that then is adopted.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the West Green Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Right, well, shall we consider...
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the West Green Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Shall we consider normal business at 2 o'clock?
Can I just hand up, because it answers, I've been trying, sort of wanting to all afternoon, all morning rather, it answers my Lady Justice Laing's question about legislation.
Right.
It is section 1B of the 2018 Act. It was something I realised that is a gap in the material. It's probably my fault because our skeleton has overlapped. It doesn't have this gap. Section 1B subsection 7 defines EU-derived legislation.
Right.
It does so using the language of enactment, and we pointed to enactment in section 20 of the Act, which you have. Enactment means essentially any instrument, I think it's described as, made under legislation.
Yes, I'm not sure that necessarily is a full answer, because I think we may need to look at Odolela if that's...
Yes, I mean, certainly the way we've argued it, which is why we would agree with my learned friend's concession, is because the origin of the Immigration Acts is the 1970, the immigration rules is the 1971 Act.
Well, if you look at Odolela, it's not, because there were rules before the 71 Act. But, I mean, anyway, but maybe just have a look at Odolela.
Yes, if we're going to bring that, it might be worth bringing Alvi, because Alvi is also obviously the case that makes it clear you now need to have immigration rules because of the terms of Section 3.2 of the Immigration Act.
Yeah.
If governing practice. So in fact, they're required by legislation.
All right. Well, you bring what you need to bring,
Yes.
and we'll see if it goes on.